Um, think about the last time you visited a random website, like really any website at all.
Right, you get hit with that pop-up immediately.
Exactly. A pop-up just completely blocks your screen, asking you to consent to cookies. And you had options, right?
Oh, yeah, you have to actively check boxes. You decide if you want to allow geolocation tracking or targeted advertising.
Yeah, or like data retention for the next 6 months.
Huh.
You can click Manage Preferences and granularly select exactly what tiny slivers of your data that website is allowed to see.
It's super specific.
It is. But now, I want you to imagine walking into a police station and an officer slides a single blank piece of paper across the desk. It has one sentence on it.
Just one sentence.
Yeah, and you sign it. And with that one signature, you have legally given them permission to download your entire digital life. They can track your past movements, read every message you've ever sent, and just store it in a government warehouse forever.
It is a staggering contrast. I mean, we demand more rigorous privacy protections from a website selling us shoes than we do from the criminal justice system.
It's wild. So today, we are doing a deep dive into how a plastic wristband like a fitness tracker and a deeply outdated legal definition of consent collided in this really brutal 2016 murder case.
We are unpacking State v. Burch. That's a 2021 Wisconsin Supreme Court decision that forces us to ask a pretty terrifying question.
Which is, does a law written by the Founding Fathers in the 1700s have literally any hope of protecting us in the smartphone era?
Right. And to map out this collision between 18th century law and 21st century tech, we are pulling from a really extensive stack of source material today.
We've got a lot to get through.
We do. We have the official Wisconsin Supreme Court rulings, the majority opinions, the concurring opinions, and some incredibly fiery dissents. I mean, they read like warnings from the picture.
Yeah, they really do. And we're also looking at the Court of Appeals certifications, exhaustive trial testimonies, legal profiles from the Wisconsin Justice Initiative.
And to tie it all together, we're actually looking at the cookie consent policy from the State Bar of Wisconsin website.
Which is such a brilliant parallel. So to set the stage for you here, this isn't just a true crime story. It spirals into something much larger.
It's a really profound look at the boundaries of consent and the reliability of everyday tech in a courtroom.
Right, and the staggering question of who owns the data of your life once the police get their hands on it. So to understand how a fitness tracker became a star witness, we need to go back to May 2016.
Back to Brown County, Wisconsin.
Exactly. May 20th, 2016. A young woman named Nicole VanderHeyden goes out for the night to a concert and a local bar with her boyfriend, Douglas Daytry.
And over the course of the evening, the two of them get separated in the crowd.
Yeah, they end up arguing via phone calls and text messages, and Daytry ultimately decides to go back to their shared home alone. But VanderHeyden does not come home.
And, you know, the next day, the absolute worst-case scenario becomes a reality. VanderHeyden's body is discovered in a nearby field.
It's awful. Investigators find her blood-stained clothes discarded along a freeway on-ramp. There's blood and hair evidence found outside a neighbor's house. It's just a brutal scene.
It is. And the Brown County Sheriff's Office, the BCSO, they immediately launch a homicide investigation. And as happens in almost every homicide investigation involving a romantic partner, the initial focus lands squarely on the boyfriend.
Yeah, Douglas Daytry becomes the prime suspect. And you can see the logic from the perspective of law enforcement, right?
Sure. They had been arguing, they separated, he went home without her. It fits a pattern.
Exactly. At trial, the jury heard really extensive testimony regarding Daytry's emotional state during those frantic hours. He testified about how his concern just mutated into panic as the morning arrived.
And she still wasn't home.
Right. When investigators finally told him a body had been found, he described his emotions becoming a complete blur.
The trial testimony details the exact moment his hope broke.
Yeah, he had been holding out hope. It was a misunderstanding. But then investigators mentioned the body was found wearing a pink bracelet.
And that was a bracelet very similar to the one Nicole was wearing that night.
He testified that hearing about that pink bracelet pretty much confirmed it for him. But during the trial, the defense was super aggressive during cross-examination.
They really grilled him.
They pressed him on conversations where they had supposedly considered breaking up. They even suggested he was distracted by other women at the concert that night.
Basically attempting to paint a picture of a fractured relationship. He was under immense pressure. I mean, he was incarcerated in the Brown County Jail for 2 weeks while this investigation swirled around him.
2 weeks is a long time when you're innocent.
It is.
Right.
But his defense attorney, Emily Lonergan, who, according to her profile on the Wisconsin Justice Initiative blog, had built a really formidable reputation handling complex cases, she worked tirelessly.
She and her team conducted substantial independent investigation, right?
Exactly. They handled evidence preservation, held multiple meetings with the district attorney, just insisting her client was entirely innocent. And after 2 weeks, she was able to walk him out of the jail, a free man.
And this is where it gets crazy. The turning point, the single piece of evidence that largely cleared Detry and forced the BCSO to abandon him as a suspect, was strapped to his wrist.
It was his Fitbit Flex.
His Fitbit. Detry was wearing this consumer device that tracks your daily steps. Law enforcement pulled the data from his specific device, and the digital log registered only 12 steps during the specific window of hours when the medical examiner determined Nicole was murdered.
Just 12 steps.
Meaning, the police looked at that digital readout and concluded that there was no physical way he could have committed a brutal murder, moved a body to a field, and discarded clothing on an on-ramp while only taking 12 strides.
A piece of consumer plastic effectively served as an unimpeachable alibi witness.
Okay, I have to pause here because my instinct is screaming at me. 12 steps.
I know where you're going with this.
I mean, if I sit on my couch and aggressively whisk eggs in a bowl, my fitness tracker vibrates to congratulate me on my brisk walk.
Or folding laundry.
Exactly. Or if I push a grocery cart through a supermarket, it thinks I'm standing perfectly still because my wrists aren't swinging. So how can a mass market gadget, something you buy at a sporting goods store, definitively clear a murder suspect?
It's a huge question.
We are talking about the highest possible stakes here. Life in prison versus freedom. And the justice system is putting its faith in a rubber bracelet.
That underlying skepticism you have is exactly what fueled the massive legal battle that unfolded later. Because eventually, the police do find their actual prime suspect.
A man named George Burch.
Right. And when Burch goes to trial, his defense team looks at this Fitbit evidence. They realize this is the exact same evidence that cleared the previous suspect and indirectly pointed the finger at their client.
So they asked the court, basically, how reliable is this science, legally speaking?
Yes. If a Fitbit is going to be the star witness that dictates who goes to prison and who goes home, it needs to be put under a microscope. So Burch's defense moves to exclude the Fitbit evidence entirely.
They argue that if the state wants to use this step-counting data to prove a timeline, they need to produce an actual expert witness to prove the underlying science is reliable.
Their argument hinged on the failure to properly authenticate the technology, because at trial, the state didn't bring in a biometric engineer.
They didn't subpoena a software developer from Fitbit.
No, they didn't. They called a computer forensic crime analyst from the sheriff's office named Tyler Belling.
Okay.
And Belling testified that he understood how a Fitbit worked on a high level. But when Burch's defense pressed him on cross-examination, the gaps in his knowledge became really apparent.
Like what kind of gaps?
Well, he couldn't explain the mechanics of how the Fitbit and a smartphone actually transmit information to each other via Bluetooth. He didn't know how Fitbit securely stores its data. He didn't know whether that data could be retroactively edited by a user, or whether the device registers false steps when it's just, sitting on a vibrating washing machine.
Or whisking eggs.
Exactly. And most crucially, he didn't know what the device's certified error rate is.
Wait, not knowing the error rate seems like a catastrophic oversight in a homicide trial.
It really forces us to look at the rules of evidence, specifically the Daubert standard. In the legal system, a judge acts as a gatekeeper for scientific evidence.
Right.
If an issue is unusually complex or esoteric, the state is required to bring in a qualified expert to explain the underlying scientific principles and mathematically prove they are reliable.
Okay, that makes sense.
But the law has a carve-out. Expert testimony is not required if the underlying issue is within the ordinary experience of mankind.
The ordinary experience of mankind, I assume that means something so universally understood that it doesn't require explanation, like, I don't know, gravity.
Sure.
You don't need a physicist to testify that a dropped murder weapon will fall to the floor.
That is the exact principle. And the circuit court judge looked at the Fitbit and ruled, this is not unusually complex. The judge drew an analogy to a wristwatch or a car's speedometer.
Wristwatch?
Yeah. The logic is that the average person sitting on a jury might not know the exact internal mechanical gear ratios of a watch, but the public generally understands how a watch functions.
And we accept its output as reliable.
Right. Since smartphones and fitness trackers have been in the consumer marketplace for years, the court ruled that the average juror understands what a pedometer does. Therefore, no expert was required.
Wow.
And the Wisconsin Supreme Court ultimately upheld this in a 6-1 ruling. Justice Brian Hagedorn, writing for the majority, stated that given the widespread availability of these devices, the Fitbit was not so esoteric that a jury needed a biometric engineer to explain it to them.
But there was a 6-1 split, which means there was a lone dissenter.
Hmm.
And from what I read in the sources, she absolutely eviscerated the idea that popular equals reliable.
She did. Justice Dan Walsh Bradley wrote a fierce dissent on this specific issue. It's really a masterclass in questioning our cultural blind faith in consumer technology.
She explicitly argued that ubiquitous use does not mean reliability, which I completely agree with. Millions of people use microwave ovens every single day. They are totally ubiquitous.
Right.
But if you put me on a witness stand and ask me to explain the physics of electromagnetic radiation and how it excites water molecules, I would fail instantly. Using a tool does not mean you understand its mechanics.
And Justice A.W. Bradley pointed out that a Fitbit is not just an old-school mechanical pedometer with a little metal pendulum that clicks when you take a heavy step. A Fitbit uses a microelectronic triaxial accelerometer.
Okay, I know triaxial refers to 3 axes, X, Y, and Z. So instead of just measuring an up and down click, it's constantly measuring movement in 3-dimensional space.
Right, forward, backwards, side to side, and up and down. It is capturing a massive stream of raw 3D motion data.
Which is super complex.
It is. And that motion data is then fed into proprietary algorithms, essentially a black box of complex math created by a corporation, to guess if that specific motion signature matches the biomechanics of a human walking.
And she argued that microelectronic triaxial accelerometers and black box algorithms are absolutely not within the ordinary experience of mankind.
Exactly. And she backed that up with hard data. She cited a massive review of 67 different studies disseminated by the National Institutes of Health.
The NIH.
Yes. And the conclusion of that comprehensive review was pretty alarming. It found that Fitbit devices are likely to meet acceptable accuracy for step counts only about half the time.
Wait, half the time? Literally a coin flip. We are talking about using a coin flip to establish a murder timeline.
Now, she wasn't stating as a fact that the Fitbit data was definitely wrong in Detroit's specific case. Her argument was about the legal precedent.
Right. She believed the court was fundamentally wrong to grant the device a legal presumption of accuracy simply because it is a trendy consumer item.
Exactly. She warned against the danger of allowing machines to bypass the crucible of the rules of evidence. If we blindly trust the output of proprietary algorithms without demanding a scientific explanation of their error rates, we erode the foundational requirement that evidence must be proven reliable before it can deprive someone of their liberty.
That is such a powerful point. So we have a ubiquitous piece of wearable tech that clears the boyfriend, despite serious lingering questions about its scientific reliability in a courtroom.
Yep.
But if the Fitbit definitively ruled out Detry, the police were suddenly back at square one. They had a body, a tragic scene, and a prime suspect with an airtight, albeit controversial, digital alibi.
So how do they bridge the gap from a cleared boyfriend to George Burch?
That's the crazy part. The answer involves another ubiquitous piece of tech, a cell phone,
Yeah.
and an incredibly broad, deeply flawed execution of the word consent.
To trace that path, we have to rewind the timeline a bit. We need to go back to June 2016.
So this is a few weeks after VanderHeyden's murder.
Right. But a full 2 months before the Brown County Sheriff's Office got the DNA match linking Burch to the crime. Over in a different jurisdiction, the Green Bay Police Department, the GBPD, is investigating a string of incidents that seem entirely unrelated to a homicide.
Yeah, the Green Bay police are looking into a stolen vehicle case. Specifically, a red Chevy Blazer belonging to Burch's roommate, Linda Jackson.
And this Blazer was involved in a hit-and-run accident and a subsequent vehicle fire.
George Burch becomes the prime suspect in that case because he was the last known person to drive the vehicle.
So a Green Bay police officer named Bordelais brings Burch in for an interview about the hit-and-run, and Burch vehemently denies any involvement.
He offers an alibi for the night of the crash.
He does. He states he was at a local bar, and he spent the evening texting a woman who happened to live near the location of the crash. Crucially, he claims he never actually left the bar to go to her house.
So also Bordelais says basically, okay, if you were texting her, can I see the text messages on your phone to verify your alibi? And Burch verbally agrees. Then Bordelais tells Burch that instead of sitting there taking a bunch of photos or writing down timestamps, it would be much easier and faster to just take the phone to a detective at the station and download the information.
And Burch, likely thinking this will just quickly prove his bar alibi, says that's fine.
But this exchange is where the legal technicalities begin to cascade into a total constitutional crisis.
It really is. Officer Bordelais presents Burch with a standardized, generic consent form used by the department. The form reads, in its entirety, I, George Steven Burch, voluntarily give Det Danielski, Officer Bordelais, or any assisting personnel permission to search my Samsung cell phone.
And Burch signs his name.
He signs it. And there are no limitations written on the form. It doesn't specify only text messages. It doesn't specify only data relevant to the hit-and-run investigation.
He just signs this single sentence on a blank piece of paper.
So what does the forensic examiner, Detective Danielski, actually do with the phone? Because I assume downloading the information is a lot more invasive than just plugging it in and copying a text thread. Oh, it is vastly more invasive. Detective Danielski performs what is known in digital forensics as a physical extraction.
What does that entail?
She hooks the phone up to specialized forensic software. These are programs designed to bypass consumer security and rip an exact bit-for-bit clone of the device's storage.
A bit-for-bit clone?
Yes. She downloads the entire contents of his smartphone. Every single text message he has ever sent or received, every photograph, his entire internet browsing history, his email caches, and every piece of background location data the phone is silently logged.
Wow.
And she takes that massive, comprehensive clone of his digital life and drops it into the Green Bay Police Department's long-term storage database.
Which brings us to the legal concept of the scope of consent.
Yeah.
Because I know that under the Fourth Amendment, a search conducted by consent is perfectly lawful.
It is.
But isn't the scope of that search strictly limited by the terms of the authorization? Like, the legal standard here, stemming from a foundational Supreme Court case called Florida v. Jimeno, is objective reasonableness.
Exactly. Florida v. Jimeno asks, what would a typical reasonable person have understood the exchange between the officer and the suspect to mean?
Right.
In the pre-digital era, if an officer asked to search the trunk of your car for a stolen television, and you said yes, it would not be objectively reasonable for the officer to then pry open a tiny locked toolbox found inside the trunk.
Because television couldn't possibly fit in a pillbox. The consent is bound by the context of the request.
Right. And Burch's defense lawyer used that exact logic. They argued that any reasonable person in Burch's shoes would understand that the scope of the search was strictly limited to text messages related to his alibi for the hit and run.
Because Bordelais specifically asked about texts to a specific woman, and Burch agreed to show him those texts.
But the state countered by pointing to the piece of paper. They argued that by signing a form that explicitly said permission to search my cell phone, without taking the initiative to write in any limitations himself, Burch consented to a full, unrestricted extraction.
I mean, that seems like such a stretch.
Officer Bordelais testified that he deliberately used the broad phrase, download the information, because in the modern era, people communicate across multiple platforms, text, WhatsApp, Facebook Messenger. He claimed he needed all the data to fully corroborate the alibi.
Okay, I have to interject here because this analogy just hit me. It is like inviting a police officer into your living room because you reported your bicycle stolen.
Okay, yeah.
You say, come in, look at the broken window where they got in. And while they're standing in your living room, they say, do you mind if we look around to gather some information?
And you say, sure, assuming they mean looking for muddy footprints.
Exactly. But instead, they proceed to photocopy every single personal diary on your bookshelf, every financial tax record in your filing cabinet, every medical file, and every photo album in your entire house.
It's absurd when you put it like that.
And then they pack all those photocopies into boxes and put them in a police warehouse forever.
That analogy perfectly captures the scale of the privacy intrusion. A physical extraction of a phone is the equivalent of photocopying the entire house. But from the perspective of the Green Bay Police Department at that specific moment, they believed they were just executing a standard forensic procedure based on a signed authorization form.
Right. They thought they were just doing their job.
Exactly. They reviewed the extracted data for the hit and run, found no evidence linking Burch to the crash or the fire, and essentially closed out their active investigation into the vehicle.
They closed the case, but Burch's entire digital life is now sitting, fully extracted, on a server in a police database. Just waiting.
Just sitting there.
And 2 months later, in August 2016, Those dormant digital files become an absolute goldmine for a completely different police department.
The timelines finally merge. In August, the Brown County Sheriff's Office, who is still investigating the Nicole VanderHeyden homicide, gets a massive break.
The DNA match.
Yes, the state crime lab returns a DNA match from a swab taken from the victim's sock, and the DNA belongs to George Burch.
So suddenly, Burch goes from a guy who beat a hit-and-run charge to the prime suspect in a brutal murder.
And the BCSO detectives naturally start running his name through their interdepartmental records to see if he's had any prior police contacts in the area.
Which is standard practice.
Very standard. They find the Green Bay Police Department file from 2 months earlier. They see the generic signed consent form in the file, and they realize the GBPD has a complete bit-for-bit download of Burch's cell phone sitting on a server.
And this is the critical juncture of the entire case.
Yeah.
The BCSO detectives decide to access and search that downloaded cell phone data. But they do it entirely without getting a search warrant.
They rely solely on the consent form Burch signed for the Green Bay Police 2 months prior, which was signed for a completely different crime.
They just log in and start digging. And what they find in that raw data is incredibly damning.
Oh, it was a goldmine for the prosecution.
They look through his internet history and see that he viewed news stories about VanderHeyden's death 64 separate times in the days immediately following the murder.
64 times.
Yeah. They also find an active Google email account linked to the phone. They take that email address, go to a judge, get a separate warrant for his Google dashboard data, and Google sends them a pristine log of his GPS and Wi-Fi location history.
That location data was the technological smoking gun. It perfectly, undeniably tracked Burch's phone on the night of the murder.
It's terrifying how accurate it is.
It placed his device at the very bar the victim visited. It tracked him to the area near the victim's house. It placed him at the specific field where the body was dumped, and it tracked him to the exact freeway on-ramp where her bloody clothes were discarded.
It was literally a flawless digital footprint of the crime.
It was. So, faced with this insurmountable mountain of digital evidence at trial, Burch comes up with an incredibly desperate story.
He takes a stand and admits he was with the victim that night, right?
He does, but he claims that they were together in his car when he suddenly blacked out. He says he woke up in a field, and Douglas Detry, the boyfriend who was cleared by the Fitbit, was standing over him with a gun. Yeah. Burch claims Detry forced him to load VanderHeyden's body into the car, forced him to move it, and that he dumped the clothes in a panic while escaping the gunman.
But the jury didn't buy it for a second. The physical and digital evidence was just overwhelming. They convicted him of first-degree intentional homicide and sentenced him to life in prison.
Right. But while the jury decided his factual guilt, the appellate courts had to decide if the evidence that convicted him was obtained legally.
Because if the search was illegal, the evidence should theoretically be thrown out.
Exactly. The BCSO detectives argued they acted by the book, according to standard police practice. Law enforcement agencies regularly share records and databases with each other. It is a fundamental part of modern policing.
But Burch's defense team argued that this second search of his data, conducted by a different agency, months later, for a completely different crime, mandated a new warrant.
His consent was explicitly for the Green Bay police to look for hit-and-run texts. It was not a blank check for the Brown County Sheriff to go fishing for murder evidence months later.
To understand why this is such a massive structural legal issue, we really need to think about how you, the listener, interact with data consent every single day.
It affects everyone. Think about how many different local, state, and federal agencies might have access to a single piece of data you handed over to a police officer for a specific, limited purpose.
It's a staggering thought.
Yeah.
And it highlights a massive paradox about how we handle digital consent versus real-world consent.
Absolutely.
To really understand how bizarre and outdated that generic police consent form was, we don't even need to look at dense legal dictionaries. We just need to look at how the internet handles our data right now. Let's look at the State Bar of Wisconsin's own website.
This is a brilliant contrast from our source material. We have the exact text of the cookie consent policy from the State Bar of Wisconsin website.
Right. When you visit a modern website today, you don't just get a blank piece of paper that says, I give you permission to search my computer. You get a highly detailed, legally mandated, granular consent pop-up.
The State Bar website breaks your data down into highly specific functional categories. It asks you to consent to necessary cookies, which make the site work.
And then it has separate toggles for preferences, statistics, and targeting. It actually defaults to denying the non-essential ones.
It lists specific third-party vendors, like Google ad tech providers, and tells you exactly what they are doing with your clicks.
The level of detail is phenomenal. It explicitly asks if you consent to them collecting precise geolocation data, and it defines precise as within a 500-meter radius.
It asks for permission to engage in cross-domain tracking across multiple affiliated websites, and crucially, it limits data retention to strictly defined timeframes.
Right. It explicitly states that the choices you make are saved for a maximum of 13 months, or that specific Google ad profiles will only retain your data for 180 days before automatically deleting it.
You have the autonomous power to accept or deny specific uses, line by line.
So let me get this straight. A random legal website has stricter, more explicit, mathematically defined protocols for tracking whether I clicked on an article about property law than the police do for downloading my entire digital identity.
Yep. Burch signed one single sentence. Permission to search my Samsung cell phone.
He didn't consent to indefinite retention. He didn't consent to cross-agency tracking between GBPD and BCSO.
He didn't consent to continuous geolocation profiling.
He certainly did not. And this granular comparison highlights how woefully inadequate traditional legal consent forms are when applied to modern technology.
Burch's lawyer argued that the scope of his consent was unequivocally limited to the GBPD to verify a specific alibi for a specific night. By retaining the full clone of his phone indefinitely and allowing the BCSO to rummage through it months later without a warrant, the state fundamentally violated his reasonable expectation of privacy.
Because a cell phone holds so much more than just call logs. It holds everything, which really forces the courts to reckon with a philosophical dilemma.
Do the rules written by the Founding Fathers in the 1700s apply to a smartphone in 2016?
Right. That is the exact constitutional question the courts tackled next, bringing us straight to the historical text of the Fourth Amendment.
The Fourth Amendment protects the right of the people to be secure against unreasonable searches and seizures of their persons, houses, papers, and effects.
Papers and effects. That's the operative phrase we have to translate.
Yes. Justice Rebecca Grassel Bradley wrote a fascinating concurrence in this case, where she dove deep into the historical context of that phrase. She reminded the court that the founders wrote the Fourth Amendment specifically as a reaction to British general warrants and writs of assistance.
Can you explain the mechanism of a writ of assistance? How did that actually work in colonial times?
Sure. A writ of assistance was essentially a permanent transferable search warrant. It was a blank check.
A blank check for who?
It allowed King George III's customs officers to enter any home, any business, or any ship at any time to rummage around looking for smuggled goods without needing any specific evidence or suspicion that the person had actually committed a crime.
That sounds like a nightmare.
It was. Justice Grassel Bradley cited the famous English case of John Wilkes to illustrate the outrage this caused.
John Wilkes was a politician who criticized the king, right?
He was a radical journalist and politician. He published pamphlets mocking the king's administration. In retaliation, officers used a general warrant to raid his home, smash the locks on his desks, and seize all his private pamphlets and personal papers just to see what they could find.
Just a complete fishing expedition.
Exactly. That outrage, along with the landmark case of Entick v. Carrington, where a similar raid was declared illegal under English common law, fueled the creation of the Fourth Amendment. The founders believed that your private papers were the dearest property a man can have.
So the modern legal translation becomes, does a smartphone count as papers and effects?
And the U.S. Supreme Court answered that with a resounding yes in a monumental 2014 case called Riley v. California.
What did they decide in Riley?
In Riley, Chief Justice John Roberts wrote that modern cell phones are not just another technological convenience. They contain the privacies of life.
Which is so true.
The court noted that searching a phone typically exposes far more to the government than the most exhaustive physical search of a house. You might not keep every letter you've ever received in your living room, but your phone contains a digital diary of everything you do, everywhere you go, and everyone you talk to for years.
Therefore, the Supreme Court ruled that searching a smartphone generally requires a specific warrant.
Exactly. And the Court of Appeals certification in the Burch case also brought up some other really interesting precedents regarding how police handle data.
Specifically cases called Gagnes I and Thompson.
Yes. Those cases dealt specifically with the mechanical problem of overseizing digital data. When police clone a hard drive or download a phone, they cannot physically separate the relevant data from the irrelevant data at the moment of extraction. They have to copy the whole thing.
Right, the software just dumps everything.
So the courts in Gagnus and Thompson essentially told the government, we understand you have to copy the whole drive to find what you need, but you cannot seize a million emails, look at the 10 you need for your current warrant, and then retain the other 999,990 emails indefinitely, just in case you want to search them years later for a completely different crime.
Which is exactly the mechanism of what happened to Burch. The Green Bay police downloaded everything for a hit and run, found what they needed, and then the Brown County sheriff went fishing through the leftover data months later for a murder.
Exactly. And because Burch's consent was contextually limited to the GBPD for the hit and run, several justices concluded that the BCSO, looking through the data months later, undeniably invaded his reasonable expectation of privacy. It was, by definition, a warrantless search of his digital papers, which violates the Fourth Amendment.
So wait, if the court admits that the second search clearly violated the spirit of the Fourth Amendment by rummaging through his digital papers without a warrant, my instinct is that the evidence gets thrown out. That is the fruit of the poisonous tree. Why didn't that happen? Why is George Burch sitting in prison for life?
That brings us to a highly controversial, incredibly powerful legal doctrine called the exclusionary rule, and its companion, the good faith exception.
We need to unpack this very carefully and remain totally impartial here, presenting both sides of the legal argument purely as facts, because this specific issue split the Wisconsin Supreme Court 4-3. It was a fiercely debated philosophical divide.
Right, so Justice Hagedorn wrote the majority opinion. For the sake of the argument, the majority actually assumed that the Fourth Amendment was violated.
Wait, they assumed it was unconstitutional?
Yes. They didn't definitively say it was or wasn't. They just said, even if we assume this was an unconstitutional search, the evidence stays in. And they justified this by relying on the mechanical application of the exclusionary rule.
If the search is unconstitutional, how does a rule keep the evidence in?
Because the exclusionary rule is not a constitutional right, it is a judicially created doctrine. The rule states that if police obtain evidence unconstitutionally, that evidence is suppressed, thrown out of court.
Right.
However, the Supreme Court has clarified in recent cases like Herring v. United States and Davis v. United States, and the Wisconsin Supreme Court affirmed in State v. Kerr that the only purpose of the exclusionary rule is to deter bad police behavior. It is not a magical right that automatically frees a defendant to correct a past wrong.
But if the Fourth Amendment is a constitutional right, how can a judge just say, well, the cops meant well, so your rights don't matter in this instance? That seems completely contradictory to the concept of constitutional law. If my house is illegally searched, it shouldn't matter if the cop was having a nice day or thought he was in the right house. The search is still illegal.
You are echoing the exact frustration of the defense. But the majority's logic is purely pragmatic. The evidence is only thrown out if the police committed deliberate, reckless, or grossly negligent misconduct.
So it's about intent.
Yes. If the police acted in good faith, genuinely believing what they were doing was legal based on the information they had, then there's no malicious misconduct to deter. Therefore, the court ruled society shouldn't have to pay the heavy toll of setting a convicted murderer free just because the police made a procedural mistake while trying to do the right thing.
It's like a mistaken delivery or a corporate audit. Like if a mail carrier accidentally puts your neighbor's incredibly revealing bank statement in your mailbox and you read it thinking it's yours, you technically violated their privacy.
Right.
But you didn't maliciously steal their mail. You just read what was handed to you. The state is saying the detectives just read the file they were handed.
That is exactly how the majority viewed it. The BCSO detectives looked at the GBPD file. They saw a signed consent form. The form had no written limitations on it.
They saw the original officer's narrative saying Burch agreed to have the information downloaded.
Exactly. The detectives had no reason to think they were engaging in illegal activity by reviewing an interdepartmental file that appeared completely authorized. They were acting in objective good faith.
The state also justified this by pointing to the second look doctrine, mentioning a case called State v. Betterly. How does that mechanic work?
In the Betterly case, the police had legitimately seized a physical ring from a suspect during a routine jail intake process and put it in a property box. Later, a different officer investigating an insurance fraud case went into the property box and took a second look at the ring.
And the court ruled that was perfectly legal because the police already had lawful possession of the item.
Yes. The state argued that Burch's cell phone data was just like that physical ring. It was lawfully in police possession via the consent form, so a second look by a different detective was fine. The majority accepted the premise that the detectives, acting on this kind of standard established logic, were not being malicious.
So the court deliberately separates the unconstitutionality of the search from the punishment of throwing out the evidence. They essentially say, maybe it was unconstitutional, but the cops didn't do it on purpose, so the evidence stays and Burch goes to prison.
But the dissenting judges saw a massive, terrifying flaw in this exact logic. And their concern is not just about George Burch, it is primarily about the future of your digital privacy.
The dissent was written by Justices Delitt Karofsky and A.W. Bradley. And they pointed out that treating a digital cell phone clone like a physical ring in a property box is scientifically and philosophically absurd.
It is a false equivalence. The dissent argued that looking at a physical ring reveals only the item itself. It has no hidden depths.
Right, a ring is just a ring.
Exactly. Searching a cell phone reveals an individual's entire life. Their thoughts, their locations, their health data, their private associations. You cannot compare a piece of metal to a digital brain.
But their biggest concern was about the practical application of this good faith exception. During the trial hearings, police officers testified that sharing full cell phone downloads between agencies is very common. They do it all the time.
They do. So the dissent is saying this isn't an isolated mistake by one well-meaning detective who misread a form. This is systemic negligence.
It is a standard operating procedure across law enforcement that completely ignores the Fourth Amendment.
Exactly. And the dissent highlights a major structural problem in the justice system that they call constitutional stagnation. It is a devastating catch-22.
Let's trace the logic of this catch-22, because this is the part that genuinely scares me about the future of technology and the law.
Here is how the catch-22 works. If the courts always leapfrog the actual constitutional question, if they always say, well, we don't need to definitively decide if searching the phone data violates the Fourth Amendment because the cops acted in good faith since no prior case law told them not to, then no new case law is ever established.
Oh, I see the loop. So if I have a smart fridge that tracks exactly when I am home and when I am asleep, and there's no law against police downloading my smart fridge data, they do it.
And they claim they did it in good faith.
And when I sue them and it goes to court, the judge says, I don't need to rule on whether smart fridge data is private because the cops acted in good faith, which means tomorrow the cops can do it again because there is still no law against it.
You have perfectly articulated the mechanic of constitutional stagnation. Because there is no ruling, the police act in good faith. And because the police act in good faith, the court refuses to write a ruling. It creates a perpetual, unbreakable loophole.
Wow.
Police never get clear, binding guidance on digital privacy, meaning they can always claim good faith, and the law never adapts to new technology. The dissent argued that you have to draw a hard line to force law enforcement to change their systemic behavior and start getting warrants for digital data, even if it means losing evidence in one case.
If police know they can just share full cell phone downloads forever without a warrant across different departments, what stops them from building a master database of everyone's digital lives based on minor traffic stops, stolen car reports, or noise complaints?
If there's no rule against it and good faith protects them, the potential for surveillance is limitless.
That is the chilling extrapolation the dissent was warning against. They argued that skipping the constitutional merits leaves us with gauzy constitutional guardrails as technological innovation outpaces legal adaptation. We are relying on outdated metaphors of physical property to govern invisible oceans of data.
Which brings us to the end of this incredibly complex web. The State v. Burch deep dive reveals a legal system that is desperately racing to catch up with the devices in our pockets and on our wrists.
On one hand, a brutal murder was solved, and the person responsible is behind bars. But on the other hand, the process exposed the absolute fragility of our digital consent.
It showed us that a mass-market Fitbit doesn't need an expert biometric scientist to put you at the scene of a crime.
And that a generic, one-sentence consent form can legally give police access to your digital soul across multiple agencies indefinitely.
Look at the tracker on your wrist or the phone in your hand right now. Every step you take, every symptom you search, every location ping as you drive across town is being meticulously logged.
We willingly trade our privacy to tech companies by clicking Allow All Cookies so we can read an article or play a game. But we rarely, if ever, consider how those same invisible digital footprints might one day end up in a police database, retained entirely legally under the guise of good faith.
If we look back at the source material, there was a specific phrase used by the police forensic examiner during her testimony that is worth lingering on.
What was it?
When asked what happens to the massive phone extractions after they are downloaded and reviewed for the initial crime, the examiner casually noted that they save all extractions for long-term storage.
Indefinite.
Indefinitely. She testified, as far back as I have been employed. And considering that digital storage is becoming virtually limitless and incredibly cheap, we want to leave you with this final, provocative thought to mull over on your own.
Are we rapidly approaching a future where law enforcement doesn't even need to investigate you specifically? Because they already have a complete, searchable, retroactive database of your entire life's data, gathered entirely by accident through minor interactions over decades.
It's those invisible breadcrumbs leading straight to a digital warehouse with no locks.
Thank you for joining us on this deep dive. We'll see you next time.